a limitation under entry 50.
Now, Lord, if the right is to only the mineral right, if the tax is to the mineral right, then that would only mean that someone who holds the right to extract the mineral, which will be mineral by a grant of a lease or some other authority.
But then are you conceding the fact that there is no limitation imposed by Parliament on the right of the states to tax mineral rights?
No, I'm not. They have their under the entry, yes. But now the next question is: has the Parliament put any limitation on that or not?
Right. So
I'm on that.
has Parliament has one aspect is that you are saying it's not a tax on minerals, but a tax on mineral rights.
Exactly. That.
But according to you, has Parliament left the area of a taxation of mineral rights open to the
No, it
state?
does not. That's what it's coming to. Therefore, the law of the Parliament would have to be tested from that angle. Has it left open or has it decided?
According to MMDR has not
Covers that. It covers that field.
Right.
It provides for levy of mineral, for example, the dead rent.
Dead rent.
Dead rent is nothing but without a tax on a right to extract mineral in future time, as and when you think convenient for you. And another important thing you also notice in the schedule to the act, the dead rent, the measure of dead rent is not per ton, etc., as you find for royalty. Dead rent measure is the extent of land, acreage. That's important. If you're not sure, have a look at it. Second schedule. So dead rent is provided under section 9A. Corresponding schedule is not the third schedule. And I would invite your lordship's attention to that schedule because you have not been shown so far that provision.
Not exercising right in respect of
You
mineral.
have the right, no, you have to retain in the right, not
Nothing to do
exercise.
with mineral exercise of mineral rights as such, because you are not utilizing the right conferred on you, and therefore you are.
No, I would put a beseech your lordship, kindly to consider. But what I will say is, you are holding on to the right, therefore you have to pay this tax. Not that you are not exercising. You are exercising the right by holding on to
No,
that
but you
right.
pay
That's all you
either
have.
royalty or dead rent. If you are liable,
If you are working, then of course.
right, whichever is higher.
That is because that's not a mechanism to get more money. That's a different matter. Because it's an option for a lessee either to work it or hold on to the right. But I'm only on the point kind of similar to Schedule 3 that gives your lordships an idea as to what is there.
Therefore, a lease of mineral bearing lands is not like a lease of any land. Suppose the government grants a lease in respect of some land. Government is still, we know that they provide for forfeiture if you have not constructed within a particular period. The idea there is that, well, you have taken a lease for a purpose, you must utilize it for that purpose. Similarly, the same concept in regard to dead rent, that, you are bound to fully exploit the mineral potential of the land which has been leased to you. If you don't,
then you have to pay this. No, but there was a situation which I'll bring to your lordship. That's another point I have to bring. There had been umpteen number of cases, my lord, where, I'm sorry, there are lots of some discussion. I remember that. So my lord has seen this third schedule, my lord, it says.
It's
will
on
also say
acreage.
rates
It's on
of
acreage.
dividend,
It's on acreage.
it's per acre. Per hectare per annum. So that is what is not contemplated to be the right of the state to tax under NT 50. But that is now being regulated, or you put it in the language of 54, limitation.
The reason why it is on acreage is because no mineral is extracted.
Exactly.
Therefore, a dead rent. If
But
mineral
it is
is
taxing the right.
extracted, then it is a royalty on the mineral.
Quite right. Absolutely right. I bow down to that observation. But when you are taxing the right to extract, that is the dead rent is in the nature of your right to extract mineral, which comes squarely under
That is
NT
the
50.
question whether payment of royalty or dead rent, whether it is an exercise of mineral right is the question. Or it is something else.
The exercise of mineral right is holding on to the right. When you exercise that right and you produce pursuant to that right, you are in a different scenario altogether. Because now you have extracted the mineral, they're out.
Fair enough. Now, what is the next point, Mr.
Yeah.
Ganguly?
And just to give a lordship an example, because my lord the Chief Justice was pleased to observe that yes, it is a kind of a deterrent that so that people don't sit on their property and you don't allow the development of the mineral, though Parliament has desired to do so by enacting this law. Similar to what happened was, there's a concrete scenario. Large number of private leaseholders had acquired leasehold rights but never used those rights. Large number of years. So what the Parliament then had to intervene to enact a law called the Coal Bearing Areas Acquisition Act. Acquisition Development. Though that law would be referable to some other entity under List 3 for acquisition is only there. But this law was enacted for the purpose of giving effect again to the mandate of NT 54 for development and regulation of minerals. And that act was challenged by, actually the suit filed was basically by state of West Bengal in this court, challenging the Parliament's power to enact such a law. So their contention was, these are our property, how can you rights of the existing leasehold rights, whosoever had had it, right to extract mineral. Where the government company came in and gave it. States will not then question further to the government, to the central government, saying that we don't get any royalty from this because you have acquired our property. And it's a huge loss of revenue. So central government will not accepted this and eventually Parliament amended the law in 1971 and made a provision under that act, introduced new provision, section 18A, enabling payment of royalty even in respect of these lands which are vested in the central government. That act I have to place before you because one place in which I am appearing that directly relates to that case. That act your lordship will find is that volume 4N L 4L below page 2. 4L page 2 of that volume, lordship will get that act. I have to place that. I'll come to it immediately.
What is the next point now, Mr.
Yes. The other point which has been already argued, but I owe a duty to the court to explain to your lordships what happened exactly in Kesoram. How did Kesoram come to be referred to a bench of 5 judges? That Kesoram itself extracts. I have to show you that. What is the controversy that the Kesoram was asked to decide? It was not whether the tax on royalty is a tax on mineral rights or on minerals, and whether royalty is a tax or these are none of these issues were conversed at all there. I'll immediately show you that that judgment. I will show you quite a few paragraphs. So the scope in Kesoram was completely different. This was not an issue at all. Much less reconsideration of what happened in the Indian cement. But I have to give it to the ingenuity of my friend Mr. Dwivedi. After the hearing was concluded by the Constitution bench, he came out with his hearing is closed. He came out, stood up to say, I have point that there is some kind of a typographical error in the judgment. This was attempted to in an earlier case, in the Odisha cement case, but given up. This was raised, so that we asked the court, are you going to take up this issue now that the hearing is concluded? So Chief Justice Khare, who was presiding the bench, said, certainly not. It was a closed chapter. So nobody addressed any argument to that bench at all on this question. Whether there was an issue or not, let's not go into that. This is a factual thing.
9, why to
Yeah.
go into all that? Actually, we will really go into a unnecessary quagmire, if we start now. No.
This is an historic fact. Unfortunately, we didn't have the transcript facility in those days.
To come another case around then,
Right.
whether it was argued, not argued.
Yeah, that's why your lordship find, my lord. Lordship do not find any mention at all in the dissenting judgment of Justice Sinha.
Just that limited significance because that was one of the reasons why the reference was made to us. Now, once a reference is made to 9.
I'll leave it at that, my lord. I only just pointed to how it had happened, but that this is important to know, my lord, that in Kesharam, this was not an issue at
If we
all.
were a bench of 7, then certainly whether Kesharam could have done this, whether there was an error in adjustment would have arisen. So we would be bound by adjustment. If we were a bench of 7.
May I just take your lordship then through that Kesharam's decision only?
No, not necessary, Mr. Ganguly. Not necessary.
No, I'm not going to that. I'm only showing you what is the scope there and how it has been dealt with.
That's okay. We'll look at your note. Something on the core now, if there is.
Yeah.
Otherwise, we'll conclude.
Just one
Mr. Ganguly.
paragraph, my lord. Should permit me, volume 5 plus 1.
Not necessary to read Kesharam.
No, I will not. I would not read. I will only give you the lordship the paragraph.
After Mr. Ganguly, Mr. Bagaria will be arguing next. Yeah. Who?
I think sequence Mr. Bagaria, Kambata, myself and Mr. Gu. Subject to 3 o'clock.
Mr. Bagaria, Mr. Datar, Mr. Kambata, and then
Is somebody raising both the palms?
I sorry, my lord, I couldn't.
No, I said is somebody raising both the palms because we found many.
Only one. No, then let me take your lordship to the Cultivating Areas Act directly, because that's an additional point. So may I visit your lordship kindly to see, my lord? Volume 4L.
what do you want to refer to it for, Mr.
My lord, for the Coal Bearing Areas Act, your lordship have not seen that. And where there is directly an argument that once the mines come out within the purview of that act, the tax at the entry 50 in any case not eligible. So I want to show you also that act, how eligible.
But do we have to deal with that? Let a smaller bench deal with these issues, particularly, I think.
What is the effect of the act?
What is the effect of the act? We shouldn't really.
Imposed by the parliament.
No, this is also,
Mr. Dwivedi, I think that's a better course of action, isn't it?
this also, my lord,
Otherwise, we start interpreting individual legislations, then we'll miss some legislation. That's not the scope of this reference.
It's a parliament.
no, we are not questioning the validity.
Broad
of
aspects
law.
of the legislations can be kept in view.
Volume बोलना है क्या? हाँ, for it.
Anything else, Mr. Ganguly? Or we
So
can now-
if you also just
Bagaria.
permit me to, my lord, this is an act which is important for the reason that it will throw light as to the scope of, my lord, entry 50. That's why I just want to tell you also what it is all about. We are not asking you also to adjudicate on the nitty-gritty of that provision, no. So volume 4L, if you also will kindly permit me. Page 2. If you also will see the objects and reasons at page 2.
Show us the relevant provision, Mr. Ganguly.
Yeah, where the provisions are, first, if you also will kindly permit me to.
4L.
Yeah, let's go to, First, see, the preamble. If it was not good, preamble, at page 5. Okay.
Which you're making, and then we can maybe look at everything again.
Section 4 is the preliminary notification which is issued by the central government once the central government has come to the conclusion that coal is likely to be obtained in an area. So, section 4. Then, a notification under section 5. It is similar to the land acquisition provisions. Effect of notification, what happens, all prospective license, mining leases, they all cease to have any effect at all. The whole purpose was to acquire the mining rights of those who are holding on to the leases and not operating the mines at all. Then section 6 is a compensation to them, that's not very relevant. Section 7.
Because, I don't think that's been the scope of the reference. It's not argued this side. If we leave the interpretation of the act, the impact of the act on the, on the appeal or whatever there is before the regular bench. Let's not go into the.
I understand that, Your Lordship. I leave it to the regular bench to go into the question of interpretation if there be any. I was only giving Your Lordship the scheme of it. It's just similar section 10, what happens?
Let's leave it, Mr. Ganguly. I don't think we need to go into the act. Unless there's a formulation which you have and then want to just sort of illustrate that formulation with reference to a particular
I'm referring to this act for the formulation, Lord, that this is clearly an example of how you can, the central government can control and exercise of its powers under NT 54 and some other powers. This is also NT 42 of list 3, because acquisition is specifically dealt with under 43. But 40, the power of acquisition was exercised, in furtherance of its obligation under NT 54. That's how I was reading to your Lordship, the preamble. Preamble says, this, that that we have large deposit of minerals, they remain unexploited, they are required for the betterment of the country and in the larger interest of industrial development in the country. Therefore, they cannot be left to be unworked for all these years. So we should acquire. That was the whole object. So this is nothing but augmentation of law and in terms of
NT 54. Mr. Ganguly, anything else now?
NT 54. A few portions, I have to show to you from the India Cement judgment, just 1 or 2 paragraphs, to indicate how India Cement dealt with the issue. So if you also kindly permit me, it is volume 1, page, it is volume 5H. No, it is not this one. Volume 5. Volume 5.
I was just reading it.
Page 1151.
Royalty is traceable to ND 20.
Yeah.
33 of India.
Yes, okay, I got it. 33 যেতে হবে না?
33 lordship is got.
Page, my lord, 1200. No, first, your lordship will just once again, my lord, see the question that was formulated by the court at page, my lord, 1155, foot of that page. Question involved in the previous special petition and the writ petition is whether levy of cess on royalties within the competence of the state legislature.
And they go on to discuss this, my lord, when
It was paragraph 24 at page, my lord, 1166. That the lawsuits are discussing the scope of entry 15 of list 2. And then referring to Anant Mills case, my lord, they also say all minerals which are under the earth can contain under certain circumstances fall under the expression land. But a tax on mineral rights is expressly covered by entry 50 list 2. If it is not under the head taxes under the heading 49 of list 2, they will render 50 redundant. So that was the argument note with regard to entry 49. Kindly turn to my lord, paragraph 29 at page 1168, where the lordships are now discussing the case on HSI Murthy's case. My lord, Murthy's case was the issue whether Murthy has correctly laid down the law or not. And then
Ganguly,
also
what are you driving at actually?
paragraph 20.
What are you driving at?
What I'm driving at is, my lord, India Cement was directly concerned with the question as to whether, my lord, royalty is a tax or not. Why?
Yeah.
Because their lordships are considering the validity of the earlier judgment in Murthy's case. Murthy said, my lord, a tax on royalty, that's what it says, on royalty is a valid tax. So that was the issue which was before the court. The court was examining whether that is correct law or not. It is in that context, my lord, their lordships observe at paragraph 29, page 1168. The passage is quoted, my lord, from HSI Murthy's case. Last 4 lines of the passage. After having said, my lord, that cess is valid on royalty, the lordship says, our attention was not invited to the provision of any law created by Parliament. In the context of section 78 and 79 of the scheme of those provisions, it is clear that the land says in the truth a tax on land under entry 49 of the state list. This is what Murthy had held, my lord. Now they are considering correctness of that properly. Next paragraph, paragraph 30, my lord. It seems therefore.
33 could be what you are driving at, I think, 33, para 33.
Yes.
I think that
I
is where.
was going to 33, but I want to show you first also this, my lord, that the lordships found that section 9 is the provision under the MFDA Act, which covers that. That is stated in paragraph 30. And what the lordships have said is, last sentence, on that is tax on royalty is not a tax on mineral right. It would therefore be in any event outside the company's state legislation. So they made again a distinction between mineral, tax on minerals and mineral rights. And in 32 first, my lord, and 33. 32 first, it is contained by Mr. Krishnamurthy that the state has a right tax minerals, which is completely different from what is the scope of entry 50. Now, my lord, that is being dealt with. Paragraph 33. In any way, royalty is directly relatable only to minerals extracted and on the principle that the general provision is excluded by the special one, royalty would be relatable to entries 23 and 50 of list 2 and not under entry 49 of list 2. Whereas the fee is covered by the central power under entry 23 or entry 52, the impugned legislation cannot be appealed. And then, my lord, paragraph 34. Having said this, they clearly said that royalty is a tax, and the cess on royalty is beyond the permissible limits of the power of the state.
This is very good.
Then they also go on to discuss paragraph 34. See the beginning. In the aforesaid view of the matter, we are of the opinion that the royalty is a tax and as such cess on royalty, being a tax on royalty is beyond the competence of the state legislature because Section 9 of the Central Act covers the field and the state legislature is denuded of its competence under NT 23 of this too. Then we note the last sentence in any event. We are of the opinion that the cess on royalty cannot be sustained under NT 49. That's another argument. And then we note the royalty on a mineral right is not a tax on land, but on payment of the user of land. Now, this is being picked up, this last sentence, to suggest that India Cement did not have the occasion to decide whether royalty is a tax or not. That, with great respect, that is the genesis of, Kesharam's beginning. That's how the Kesharam begins, let's say, to distinguish this judgment of 7 judges. And that's how the Russians have found some possible error, etc., etc. Whatever is that. That part I don't want to go over it. But this is because of incorrect reading, of this paragraph 34, which flows from what has been held in the earlier 2 paragraphs. And it is very clear from the earlier 2 paragraphs that cess on royalty is a tax. Royalty is a tax and cess on royalty, therefore, is forbidden. Very clearly says so. And there is also a reference to a judgment by Justice V.S. Verma, then addition. He was then there, as his lordship then was acting Chief Justice. He has also held that the development says under Section 9 of the Madhya Pradesh Act is ultra virus. But they also did not go further into it because the appeal was pending before this honorable court.
Royalty.
What I was referring to that Coal Bearing Areas Act for the limited purpose. That how does that act also reflect on the interpretation that you're also going to place on NT 50 is this. That's a law which has acquired all the rights of the existing leaseholders. And then the government, in furtherance of its objective under NT 54, for further development of mineral development, has compulsorily directed that those lands would have to be developed for the purpose of mineral development. And that's how they appointed the government company. That act now provides by an amendment to Section 18A without payment of royalty. So these government companies are paying royalty to the state because of that new introduction under Section 18A is from 1971. At the same time, now there is a further demand under the Act from the same companies by saying you now have to pay a cess, which is not calculated again at the rate of royalty.
Right. Thank you, Mr. Ganguly. We'll, now, after lunch, Mr. Bagaria, we'll hear you after lunch. For 15 minutes, we'll give Mr. Bagaria and then Mr. Dada.
May I address after Mr. Bagaria?
We are going to conclude all arguments on this side at sharp 3 o'clock. One second. All of you sit down together
Your Lord,
Whoever, one
Your
second.
Lord, my,
We are not going to do this. We are not going to haggle ration time between council. That's for you all. Between all of you, you decide you've got 1 hour. Who will take what? If one person takes the entire hour, I'm sorry, we'll have to conclude at 3 o'clock.
Lord,
So we leave it entirely to your good allocation on who will allocate, how you will allocate time the last 1 hour before you
Lord,
conclude.
I'll take 5 minutes because my case is completely
It
different.
seemed to be, my English seems to be improperly understood. You may take 5 minutes, you may take 50 minutes, you may take 59 minutes, 59 seconds.
Lord,
But that eats into somebody else's time.
just 5
All
minutes.
of you.
Your Lordship will
Why don't you
permit me just
understand what I'm trying to say?
Lord.
Why don't you understand what I'm trying to say? At 20 council, if we take 5 minutes for all of them, it goes to 100 minutes.
Lord, as far
So
as
between all of you, at lunch as you leave the court, please ration out the time inter se. We are giving now 1 hour. We have made it, yesterday we said till 2 o'clock. We have extended it by 1 o'clock, by 1 more hour. 3 o'clock, Mr. Dwivedi will start arguing. Between all of you, decide how you will divide that 1 hour between ourselves. We have no difficulty. We'll hear everybody within that 1 hour.
May I just say then that will your Lordship segregate that Mahanadi coalfields and refer it to a regular bench? Will your Lordship segregate Mahanadi coalfields? What's segregated is done tomorrow?
That segregation we'll do tomorrow.
Respondent number 87, because
We
that's
can't do it like
covered by the
this. We
central
can't do it
legislation.
like this. You know, there'll be a mess if you start
Very
just
well.
throwing things like that.
Very well.
What is Maha?
We are looking at it
Manoj, on-
conceptually. Tomorrow, all of you give us that these are the matters which have to be detailed. That's why we said that.
We'll do, right.
Manoj, on behalf of the NTPC, we'll go by what the learned solicitor has said, Manoj.
All right, Mr. Bagaria, then after that followed by Mr. Khambata.
Yes, Manoj. Yes.
And yes, Mr. Bagaria, Mr. Datar, Mr. Khambata.
Lordship put Khambata, he's got some difficulty after.
All right,
Let Khambata go first, I'll follow him.
all right. So Mr. Bagaria, Mr. Khambata, and then Mr. Datar.
And
Yes.
All within 1 hour.
5 minutes.
All, we'll try, we'll do it. If your lordship says so, we
You
have.
may be entirely right, but just appeal to the seniors who are preceding you. That's all. I'm so sorry, I'm responsible for the delay. I had a meeting which spilled over, that's all.
Well, we have divided that 60 minutes between ourselves.
It is coming to 62 minutes, Murad. Juniors want 1
All
or 2.
So, Mr. Bagaria, how much of the allocated time do you get?
20 minutes. Now.
20, all right. Let's get started.
I'll try to finish up with that.
Thank you.
Well, I'm appearing in two of these matters. Civil Appeal 1883 of 2006. The Steel Authority of India. And a brief synopsis is filed, that is at page 43 of volume 2A. Lordship need not open it, I will not go into that. Civil Appeal 1883 of 2006. And the second one is Civil Appeal 6135 of 2013, that is in the case of Birla Cement Works.
What is the submission, Mr. Bagaria?
Alright.
What is your submission?
Well, this first submission, I'll straight away come to entry 50.
Sorry?
I'll straight away come to entry 50.
Right.
Because much has revolved around entry 50. I need not read that, your lordships have gone that a number of times. It is into three parts, or if I may say, three attributes. Taxes on mineral rights. That's the first attribute. Subject to any limitations imposed by the Parliament. That is, my lord, the second attribute. Third attribute is by law relating to mineral development. For each of these three attributes are very, very carefully worded and very carefully put into the entry. But what is the uniqueness of this entry? It has much has been submitted. I adopt all the submissions of the learned solicitor and earlier counsels. If I may summarize, well, in all the taxing entries in list 1 and list 2, this is the only entry providing for subject to limitations, subject to any limitations by Parliament. So that sort of restricted coverage is not in any other entry. And I mark the expression subject to any limitations. Similar, the entry itself is not unrestricted. The entry itself is giving the field, as your lordship said, well, these are the entries for the legislative fields. The field relating to taxes on mineral rights. That field is allocated to the state legislatures. That allocation itself is conditioned, restricted, and subject to. But that conditioning can only be by a law, imposed by law, made by the Parliament. And that law must relate to mineral development. Parliament may make any sort of law. It may make hundreds of laws. But no, for imposing the restrictions under the entry, it must necessarily be a law relating to mineral development. But these are the three attributes, very carefully chosen words. Any limitations imposed by Parliament, by law relating to mineral development. But if you look into the lists, the only entry providing for a law made by the Parliament relating to mineral development is 54. Because law made by the Parliament is only in list 1. Leaving aside list 3 for the time being. And in list 1, 54 is the only entry. I'll also mark at this stage one important fact. had checked up all the three lists. This expression mineral development that appears only in the three entries today, what is being considered by my lords. 23 of second list, 50 of second list, 54 of first list. All the three lists, they use the expression mineral development. This expression is not appearing in any other list. So what is the significance? Immediate question your lordship raised, my lord, earlier also. All right. If that be so, how do you denude the state legislature of the power to levy taxes on mineral rights? My utmost respectful submission is that denudation automatically comes in by reason of the entry's own limitations and restrictions. That is a constitutional limitation inbuilt in the entry. By reason of the entry itself. How that comes in? The moment there is a law made by the parliament under 54/1, 54 list 1, and that touches on the mineral development, then to that extent, the denudation occurs. And the entry's power gets eclipsed to that extent. Immediate next question would be, all right, what is that law?
And what is that extent?
Yes.
What is that extent?
Absolutely. But my lord, the Honorable Chief Justice on that day was putting the question, by whom, how, and what? By whom the parliament, the entry itself is. How? The entry says by law relating to mineral development. And what? For that we need to go to MMDR. My lord, MMDR was placed before my lords in extenso by the learned solicitor. I won't take your lordships into all the sections again. Only I may give a reference to some of the sections. Your lordship may make a note of that. What MMDR does, every possible conceivable concept relating to mines and mineral development gets occupied, and gets occupied along with the financial obligations, along with the finances, along with the limitations. If that be so, if that is the correct reading of MMDR, what necessarily follows, subject to any limitations imposed by Parliament, that comes in. So that limitation on the state's powers.
But assuming that the MMDR occupies every possible field of mines and mineral development, does that impose a limitation on the taxation of mineral rights? That's the question you have to answer.
Does that impose a limitation on the taxing power?
Right.
Taxing power. That is the question.
Right.
That is the question.
Which are those provisions? Just tell us.
No, not the provision. I'll tell you, lordships. What MMDR does, your lordships have seen the preamble and other things.
Right.
Statement of objects, etc., etc. There are 2 or 3 very important features of the MMDR.
Yes.
All possible conceivable rights, reconnaissance, mining, and other connected obligations and rights, they're all taken care of in MMDR. Connected to that, as an intrinsic measure to the development and regulation, MMDR provides for various financial obligations which are in the nature of imposts. I will not use the expression tax for the time being, but they are imposts. whatever meaning we may give to impost that is defined in 366, let us confine to that meaning. So different types of financial obligations are being created by MMDR. Not only created, my lord, along with the limitations inbuilt into each one of them. So the moment that limitation on the financial obligations gets created by MMDR specifically, then those limitations cannot be breached. Then that is what is the occupying of the entire field. That entire field is getting occupied by reason of making the provisions for mines and minerals in all their aspects. Along with what are the financial outgoes which are.
But there's a fallacy. The field of taxes on mineral development, that cannot be occupied because it's a field exclusively assigned to the state.
That is why
Occupied field can arise where an entry in the state list is subject to an entry in the union list. Union occupies the entire situation. Alternately, it can occur within the concurrent list. Now, in this case, the entire field of taxation of mineral rights is assigned to the states. Therefore, it can be only by virtue of a limitation under the Central Act that the states are precluded from exercising the right to tax the mineral development. Now, where is that limitation?
that is what I was coming to.
How do you trace it? Occupied field will not help you.
That is what I was coming to.
Because the field is exclusively assigned to the state subject to limitations.
So that subject to, we cannot bifurcate.
Right.
That subject to is a part of the entry. That subject to is inbuilt as a limitation.
You show us which are those limitations which have been imposed under the MMDR Act, which affects the taxing power of the state.
Kindly allow me to place only the relevant sections.
Just tell us, you can enumerate and tell us what those sections are.
I'll enumerate in this way. Let us start with royalty. Going to other sections also, I'll just give the section numbers.
Yeah.
Well, royalty, the rates are fixed. They are on all India basis to maintain the uniformity by reason of the national importance of minerals. Not only the fixation of the rates, but coupled with the right given to the Parliament under subsection 3 of 9 to amend or enhance once in 3 years. Even if the Parliament itself desires, that revisional process or exercise cannot be done in violation of subsection 3.
Right.
So the totality of the rights, totality of the outgoes, totality of the imposts that can be levied in respect of that particular exercise that is inbuilt in the section. Now, if on that, what is royalty? My lords have been discussing it for last few weeks. One thing cannot be denied, whether we call it a tax, whether ultimately what your lordships holds. Definitely, a right in that mineral, which is taken away after extraction, that is parted with. That mineral is gone. And that is why it is on per metric ton basis or ad valorem basis, depending upon how much do you take and extract and dispatch or you consume. Now, kindly note one important aspect. In any of the 3 lists, the state has not been given, or let us say there is no entry providing for taxes on minerals. list 1, list 2, list 3. There is no entry called taxes on minerals. It has been gone into in India Cement also. It has been specifically noted. The only entry on which state can fall is 50, taxes on mineral rights. Now, if that right gets eclipsed by reason of the limitations imposed by Parliament, by a law relating to mineral development, and that is MMDR, then so long as that limitation continues, that eclipse continues.
Which are those restrictions?
Garia, you have 5 minutes to go for your 20 minutes to end. Please tell us which are those restrictions?
Very well.
Which are those
Very
limitations
well.
under the MMDR?
Can you just make a note of the sections?
Is it a tax on minerals under the MMDR Act?
Royalty is a tax or not a tax. That is a separate issue. Now, royalty is definitely calculated if your lordship sees the sections.
What is your submission on royalty?
But if your lordship sees section 9, on what basis it is being payable? Just allow me to place section 9 only.
Just formulate it. We have seen it now many times. Just formulate it.
The holder of a mining lease.
No, what is your submission? Don't read it. Just formulate it.
These 2 lines reading is important. I will not read anything further. The holder of a mining lease granted before the commencement of this act shall, notwithstanding anything contained in the instrument of lease or any law in force at the commencement, etc., pay royalty in respect of any mineral removed or consumed by him. So the conditions precedent are, he must be a holder of the lease. Now, by reason of holding of the lease, we acquired the mining right or the mineral right. And then the calculation that is getting quantified based on how much is extracted and dispatched. Whatever way ultimately your lordships may decide, whether it is a tax on mineral right or a tax on mineral, state cannot get the jurisdiction.
But is it a tax at all?
Doesn't matter. Let us call it impost. Let us call it a levy. That field by reason of this levy, that is getting occupied. Irrespective of it's being called a tax on mineral or not. Because even if it is a tax on mineral,
Field of royalty is occupied. You're right.
well, a tax field of that financial imposition, that financial impost on exercise of that right, that is getting occupied. And well, if you see the entirety of the act, as the learned solicitor was pleased to place before my lords, every aspect, prospecting, reconnaissance, mining.
All right. Anything else, Mr.
Yes,
Bagarian?
just within 5 minutes I'll complete.
3 minutes left. We'll be
Very
we will down
very
to the finish now.
very well. Kindly take the sections. Sections are, my lord, 8, 8A,
Section 8?
8, then 8A,
Yes.
9,
Yes.
9A, 9B, 9C, 11D, 13, 18, 25. These all relate to different types of financial obligations and financial matters, financial outgoes.
So according to the field of royalty is occupied, including all financial imposts on the exercise of these rights.
My lord, not only royalty,
That's why I said including
everything connected to mines and mineral obligations. I mean,
all financial imposts.
all financial obligations.
All right,
And
thank you,
they are
Mr.
getting occupied as an intrinsic part of development and regulation.
Thank you. Thank you.
But only one section, we have got a note, section 28.
Yes.
Even the notification by which the rates are changed, that 3 yearly, that is required to be placed before the Parliament with approval depending upon
Thank you.
etc., etc.
Yes, Mr. Datta, thank you.
My lord, can we make a note of, other day Lordship asked, how can a form, that is Form K, in which the lease deed is given, that have any bearing? My lord, this Form K is a statutory form under the section. Can you only make a note of those sections?
That's okay. It was statutory form, no
See,
difference.
statutory forms.
Absolutely.
So there is a
We got the
there are
point.
judgments.
Yes, Mr. Datta. Thank you, Mr. Bagaria. Yes, Mr.
Kambata will
Datta.
take 10 minutes. You wanted to finish first.
Who?
Mr. Kambata.
Mr. Kambata.
May I be, Milord,
Would you Lordship give me 1 more minute only?
No, Mr. Datta. Thank you.
My lord, 1 more minute only for mentioning the name of an act. Only for mentioning the name of the act.
What is the
The
act?
other day, Lordship asked the question, is there any other law under 54 relating to mineral development? There are 2 other laws relating to coal. One is Coal Mines Conservation and Development Act 1974. That is at page 1873 of volume 4.
We'll look at it. Yes, Mr. Kambata.
Lord, I'm grateful to your Lordship for giving me this opportunity of addressing virtually. I'm sorry, my Lord, for personal reasons, I couldn't be here physically before your Lordship. So, my Lord, I'll restrict myself. I have 10 minutes and I've heard the argument, my Lord. I know what apprehensions are troubling my Lords, and I seek to address those. Lord, I want to make 5 points on entry 50. As we have seen, entry 50 permits the states to tax mineral rights, but it is subject to any limitations imposed by Parliament by law. The first submission, therefore, is that the states do not have exclusive competence to tax even mineral rights. I'm not getting into the issue of whether mineral rights is narrower than minerals, but that has been dealt with. But whatever the subject matter is, the states do not have exclusive competence. It's always subject to Parliament. I say this because if my Lords see my written submissions in volume 2G, pages 2 to 17, I have extracted a portion from the case in H.S. Dhillon, which enunciated the test thus. It said any tax, any matter, including tax, which has not been allotted exclusively to the state legislatures, will fall into the province of Parliament. Because as we know, Parliament has the residuary power to tax under Article 248(2) and read with entry 97. So unless it is allotted exclusively to the state, it would always fall within Parliament's power. That's point number 1. My submission is...
Mr. Kambata.
Yes, madam.
Allotted exclusively to the state legislatures is not inconsistent with limitations on the exercise of the power.
That is right. That is right. I accept that. I accept that. I accept that.
Therefore, the field is not given to Parliament. The field is exclusively assigned to the states, but it is limited by a law which is passed by Parliament in the interests of mineral development.
Lordship, please. Maybe take that, my Lord, as the first. I accept that, my Lord. I'm not saying that Parliament can step in without imposing those limitations by a law relating to mineral development. The second point, therefore, is linked exactly to that. That law pertaining to mineral development is empowered by entry 54. And as the paragraph in synthetics and chemicals that Dr. Singhvi referred to, paragraph 40, I won't read it again. It says entry 50 is the one exception to the rule that a power to tax cannot come from a general entry. It says the power can come from entry 54. That's what 7 judges, your Lordships, held in synthetics and chemicals. More importantly, and I rely on Sirvai, a passage from Sirvai as well as in Hindstone, your Lordships, the judgment, the power to regulate will include the power to prohibit absolutely. And if my Lords would kindly see my written submissions for one moment, at page 7 of those, para 18, I've set out the passage from Sirvai which might be of some assistance. Page 7 of the written submissions, para 18.
Just 1 second.
It's volume 2G.
2G, volume 2G, page 2, it starts, and at page 7. My Lords have that?
Yes.
May I just read that? A tax on mineral rights is made expressly subject to any limitation by Parliament by law relating to mineral development. Consequently, Parliament would have the power to regulate or prohibit the levy of a tax on mineral rights if such levy obstructed or hampered mineral development. And even generally, as I said in the judgment of Hinstone, 1981 to SCC 205, your lordships have taken the view power to regulate includes power to prohibit. Now, if the limitation imposed in entry 50 prohibits, then as felt from the Honorable Chief Justice this morning, there would be a vacuum, because then nobody would be able to tax mineral rights, which can never be, because the residuary power to tax is always with Parliament. And therefore, if the limitation effectively prohibits, then in my respectful submission, Parliament would have competence not only under entry 54, but also read with its residuary powers under 97 and 248. And the third point is, of course, the very language of entry 50 by law relating to mineral development imports the fact that in this law, limitations at least can be put on the taxing power. Therefore, they can be related to the field of taxation. Your lordships have held in state of Karnataka and Meghalaya also that the word subject to take the entry completely out of the scope of powers of the states. The word subject to an entry 50. I'll show that later if I have the time. The fourth point, and this is, I think, my main point, and others have made it, but I just want to substantiate it, Milord. Entry 54 envisaged a complete code on the law relating to mines and mineral developments. And this would include taxation because of the language we find in entry 50. We've seen the sections, they've been shown to my lords by the learned solicitor. They are extensive, they purport to cover the full range of matters as was held in Tulloch's case at para 12 and 14. But specifically, there is a section 25, which we saw this morning, which permits the government to recover any areas of rent, royalty, tax, fee, or otherwise. Expressly uses the word tax, which means the scheme and scope of the act is expressly, it covers tax as well and a recovery of tax. And Dr. Singhvi has already pointed out why royalty is a statutory impost. Dead rent under 9A would be clearly a tax. And even 9B and C are cesses computed on the basis of royalty, which are in the nature of taxation or impost. Now, the legal consequence of a complete code, as your lordships are familiar with, I have set out at paras 30 to 35 of my note. My lords would kindly quickly go to page 11. Your lordship's judgment in the arbitration and stamp pack matter. I've set out the passage at page 11, relying on the genesis of an idea from Justice Tulsapurkar sitting in the Bombay High Court, that if an act is intended to be an exhaustive or complete code, it impliedly excludes all other laws. So a complete code on mines and minerals which includes the power of taxation, will exclude the state's power. And I've set out a passage from Sirvai. If my lord will just see that at page 11, para 31 of my note, he actually refers to what the consequence of the MMDR Act is, was entry 50. He says, and I quote in para 31, in the first of these cases, relying on a judgment of the Mysore Act, it was also held that the state legislatures lost their power to legislate under entry 50 list 2, and the provisions of the Central Act of 1957, and particularly section 25 of that act, supported this conclusion. That's the fourth point. The fifth point is that under our constitutional scheme, limitations include implied limitations. They are not limited to express limitations. And if my lords would just kindly see para 11 of my note, page 5, I have extracted some portions from Kesavananda, which explain that everything is not said expressly in our constitution. Limitations can be implied and must be implied. And they can be implied either by necessity or from the scheme of the constitution. If my lord would just see para 11, page 5. Just the first two extracts, I'll just read. From Justice Sikri's judgment to para 210, I come to the same conclusion by another line of reasoning. In a written constitution, it is rarely that everything is said expressly. Powers and limitations are implied from necessity or the scheme of the constitution. And the next two extracts also speak of, if you imply that, then it acts as a corresponding limitation on the states, the power of the states or provincial legislatures. So for the very structure and construct of entry 50 read with 54 shows that the intention was to place this entire scheme, including taxation, because one can't delink taxation from mineral development. If a state heavily taxes mineral rights, it might thwart or retard mineral development in that state. The whole idea was to unify it. Now I have 3 points on unification. The first is, and I've said this out, since my time is limited, I want to just point out at page 13 of my submissions, I've referred to the 1948 MMDR Act. Because there was an act before this one in 1948, which expressly contemplated taxation. And one must remember this was made by the Dominion legislature, which was effectively the same as the Constituent Assembly at that stage in 1948. So they expressly permitted taxation as part of the MMDR Act 1940. That's point number 1. Point number 2 is, let's go back to the Government of India Act, because now may I request my lords to see para 44 of my note, because for convenience I've set out the respective entries. This is very illuminating. The entries are almost identical. And if my lords see para 44, page 14, entry 36 is the equivalent of entry 54, entry 23 is 23, and 44 is the current entry 50. Now, there are debates of the House of Commons. I agree that they're not authorities to be cited, but it's illuminating to see those debates. And if my lords would just see, I've extracted them for convenience in the annexure to my submissions at page 18. I would have shown them at length, but there's no time. So volume 4, they are contained in volume 4M from pages 54 to 58. And the anxiety of members there was to put to the then Solicitor General in England that should not there be a complete code, and should not all powers, including power to tax mineral rights, be vested in the federal legislature, and on provisions near identical to ours.
You had mentioned the 1948 Act.
Yes, madam.
And you said that the expression taxation was specifically used therein.
Yes, madam.
Now, we haven't gone so much into detail, but you see, in the 1957 Act,
yes, madam,
the taxation thing has come only in the recovery section. What was the difficulty for the 1957 Act to also specifically say taxation? And that would make our task a little simpler, instead of
I understand.
say that royalty is an exaction and go back to the definition of taxation.
Even in the 1948
answered in the 57 Act. Because you may be right there that, the Union government has the power to exclusively sort of pass laws on the subject, but has it denuded to the extent of taking away the right of the state to also impose taxation on under entry?
My lord is right, my lord. We are before your lordships because there's not such an express reference. But reading the scheme of the Act, for example, in the 1948, the reference is in the rule-making power. The power to make rules for levy and collection of royalties, fees, or taxes. I've said that out in my para 41. All this is internal evidence to show that the range of the act intended and did cover taxation as well, in whatever name called. Because if you pluck out taxation and give it to different states, there will be a regime which will be inconsistent all over the country. That was not the parliamentary intent. And that the debates which I've set out in Annexure A, I've extracted some of the questions and
Mr. Kambata, we'll have a look at it. Thank you. Thank you, Mr. Kambata.
I leave that thought with your lordships that the whole intent will be subverted if implied limitations are not read into the power under entry 50. That's the crux of it.
Thank you. Yes, Mr. Datta.
Maybe,
Thank you, Mr.
Lord,
Kambata.
I made a PowerPoint presentation, but before Mr. Darius Kambata concluded, there is a very important passage in the Joint Committee in 1933-34, which prepared the Government of India Act. And I just flag that the original entry 23 of List 2, said that tax on mineral rights, they were no subject to limitation. And there was a general power given to the federal government. A member of the committee called Lord Percy, he flags the issue and says, if you give complete general power to the federal government and unlimited taxing power to the provinces, then the very regulatory power of the federal government will be in jeopardy. That is why then they put subject to mineral rights. I'll give that passage from Lord Percy, and the Solicitor General agrees. Yes, this is a very valid point, because unlimited taxing power can completely jeopardize the regulatory power of the federal government. Now, my Lord, I'll come to my submission straight away. My Lord, first of all, the taxing powers of the state. There are normal allocation of taxing powers. There are 12 taxing powers given to the union, entry 82 to 96, 92B, and 16 subject matters given to the state government. That is 46 to 62. It's now one less because entry tax is gone, Octroi is gone.
And to the union, which was one?
Union 12 subject matters, and to the state 16,
Entry
now 15.
82
to 92B.
Yes.
And for the state governments, entry 46 to 62. Of course, now 55 is deleted after GST. But out of these 15 taxing powers,
54 is deleted.
Sorry, my Lord.
The 54 is deleted.
55 is deleted. Entry tax. Entry tax.
Oh, 85. Yes, 55.
Because now it's one nation, one tax, so there's no
Right.
check post and all that. Now, my Lord, out of these entries in the state list, 3 entries use the word subject to. Entry 54, the power to levy sales tax, is subject to 92A of list 1. My Lord, I'll give a complete note, my Lord, to save time. Entry 54 is subject to entry 92A of list 1, interstate sales. Entry 50 is subject to a law made by Parliament. And entry 57, motor vehicles, is subject to principles in entry 55 of list 3. So 3 taxing entries are subject to something. Now, the word subject to has been subject to a lot of interpretation, and a recent judgment by my Lord Justice Gawai and Justice Nagaratna in the case of Baharul Islam, Lordship will just make a note, 2023 SCC online. Page 79, 2023 SCC online, page 79. Para numbers 85 is the most important. Subject to means yields to. So a taxing power which uses the word subject to X must yield to X. Now take 50, my Lord. I'll not get into entry 54. If I have time, I'll mention that. So 50 says subject to a law made by Parliament. So my submission is this taxing power is still a state power. There's no question about it. Because all the money goes to the state. All the money goes to the state. But it is subject to a law made by Parliament, meaning the taxing power of the state must yield to parliamentary legislation. And what has parliamentary legislation done, Lord? Lord, I am taking the plea in my slide number 2. Lord, I took the liberty of making a PowerPoint so it will save time. Lordship just sees slide number 2. I'm just going to refer to slide 2 and 4.
Page number?
Slide number 2, my Lord.
Where do we get that?
I've made a PowerPoint presentation. I got hard copies if your Lordship wants to save time. Lordship may just take the hard copy. I just got 10 minutes.
No, just one second. But written submissions volume?
No, I gave, Lord, what happened? I gave written submissions earlier.
PowerPoint.
In written
Volume 2 is there.
Volume 2, what page?
The PowerPoint is there?
Folder volume 2. There's a separate file.
Well, can you just take a hard copy, my lord? We've got 10 minutes.
Quality presentation is there.
Yes.
Very much there.
What page number, my lord? Your lordship has got slide 2, my lord. I'll just give a hard copy in case your lordships are finding it. Yes. Now please come to slide 2. Now I'm submitting what Parliament has done. Slide 2, your lordship comes to limitations on taxing power, my lord. My lord, my submission is, all your lordships have got it, no? All my lords have got it. List. Yeah. My lord, can I pass on a hard copy in case it's
there in it.
Yes. Now, my lord, I am submitting that when you say taxes on mineral rights, when a legislature has the competence to make a law relating to tax, it basically can decide on 3 components: the levy of tax, the assessment of tax, and the collection of tax. My humble submission is, what Parliament has done is, it has divided minerals into 2 parts: major minerals and minor minerals. On minor minerals, under 15, state can levy tax. In Tamil Nadu, they call royalty on major minerals. They call it seigniorage on minor minerals. But both are basically taxes or imposts. Now my submission is, why did Parliament do this? Parliament did it, in my humble submission, to impose financial guardrails or financial limitations in national interest. And I'll draw a parallel to sales tax. So the first submission is, Parliament has imposed limitations on major minerals. They have set out in second schedule what are the major minerals. They have specified how much you can tax, either so many rupees per ton or 5% ad valorem, 20% ad valorem. And then, my lord, allocation of taxing power, taxing revenues. Insofar as 9 is concerned, Parliament says entire thing goes to Consolidated Fund of State. Come to 9B. 9B, District Mineral Board, it says it will go to the district. Doesn't go to the state. It goes to a trust to be used for the purpose of the district. So what Parliament has done is, this is how the taxing powers has been regulated by Parliament. So they make a law which imposes the levy, but the entire funds go to the state. And this is what I've said. Now, my lord, kindly come to slide 4. Please come to slide 4. I have drawn a map of Tamil Nadu. Lordship has got the map of Tamil Nadu.
Yes.
My lord, what I've done is, what is the lordship kept asking the question, what is the interplay of 49(2) with entry 52? Now, I'm just making a suggestion for lordship's kind consideration. Now, tax on land and buildings, land will be a genus and mineral lands will be a species, because not the entire state may not be a mineral. So what I'm submitting is, under the Mining Mineral Development Regulation Act, you have reconnaissance permit, you have this permit, and ultimately a mining lease is given for a period area not exceeding 10 square kilometers. It can be extended depending. So some mines can be 30 kilometers, 40 kilometers, etc. Now I'm just suggesting to your lordship that whatever is the black dot represents the area for which a mining lease has been allotted. And who gives the mining lease? The state government with the approval of central government. You make an application to the state. And so my humble submission for lordship's consideration is, the black dot area is the entry 50 tax. Rest of the state is the 49 tax. And on the black dot area, they cannot be both a 49 tax and a 50 tax. That's the submission. Now, my lord, third point on why royalties are tax. My lord, I am very clear, royalties are tax. You can call it impost. Let's not quibble on words. It is a tax, it's an impost. And why do I say it's a tax? On India Cements, where lordship sees, the opening page of India Cements is page 1155. And at 1156, my lord, Justice Nagaratna asked the question, what is this royalty? The opening paragraph of Justice Mukherjee's judgment says, India Cements is paying royalty at page 1156 under the Mineral Concession Rules 1960, which is under the 57 Act. And please see, what do they say? Royalty, limestone, government land, 75 per ton, subject to rebate. The schedule. Now, my submission is, what are the indicia for a tax? Typically speaking, because if you apply the Bambach test, royalty is not a tax, then what is it? Is it consideration? Is it rent? It fails because the indicia for a tax is, it is normally given at a particular rate. The word rebate, ad valorem, schedule, alteration, all these are factors which are very, very unique to a tax. Consideration under 2D contract is nomen juris. It relates to a contractual relationship. In DK Trivedi, Justice Madan said a mining lease is not an ordinary contract. So my humble submission is royalty is a tax. That's the first submission. Secondly, the district mineral board is a percentage of the royalty. That is also a tax. And finally, my lord, I'll say why India Cements was wrong. Oh, sorry, why Kesoram was wrong. India Cements, what happened was, the royalty was under these mineral concession rules, parliamentary levy, parliamentary rules. The Tamil Nadu government under section 115 and 116 of the Panchayats Act said the cess will be at 45% of the royalty. They said 45% of public revenue, and then they amended the explanation and said land revenue in public revenue includes royalty. Now, Kesoram says cess on royalty is a tax, but royalty is not a tax. In my humble submission, it's a logical fallacy because 99.99% of the cases in tax law, everybody who practices tax knows, cesses and surcharges are piggyback levies. They are always related to a mother levy. Education says 12.32% of the service tax. Higher education says 0.6% of income tax. So if the cess on service tax is a tax, then it's paradoxical to say that the mother levy is not a tax. And that's exactly what Kesoram does. They say, no, royalty is a tax is a typo, but cess on royalty is a tax. Now, if cess on royalty is a tax, by logic, my lord, the royalty has to be a tax. I'm putting the inverted paradox. And finally, my submission is royalty is also tax because it satisfies all the four tests of Govindaram Gangasaran. Your lordship sees, I've given in the last slide. What are the four attributes of tax? I've given in slide number 8. Taxable event, person liable, rate of tax, value or measure. All these things are satisfied. And finally, not just 1 minute to say how Parliament subjects it to levy. Take sales tax, not just one, I'll conclude. Entry 54, till this Bengal immunity, lordship, now the full confusion in Bengal immunity, which state can levy tax, United Motors and Bengal immunity. Ultimately, the validation was upheld in MPV Sundaramaiah. After the 6th Amendment, they introduced 92A and said, what was an absolute power of the state was taken away and made subject to 92A. So what happens in 92A? Central sales tax. Central sales tax puts two limitations. It under section 14 makes declared goods, which include many of the minerals also. Otherwise, each state can levy whatever it wants.
Thank you, Mr. Datta.
I think I'm less than 10 minutes. Not any. Yes.
See, not only you, others have also argued this. Money going back or the entire money is usurped by the state. Should that be the logic for?
Yes, I'm very grateful. But I'm just, my Lord Chief Justice also raised the point. You keep saying it's a tax on, it's a state tax. Just think for a moment. Just suppose Parliament tomorrow says, I will make the law and I will keep the entire money with me. That could be a serious challenge because you can't make it a state levy and the entire funds goes to the Consolidated Fund of India. Because the point is, why I'm saying
that
it's
is simple enough. But if we understand that state has a power to tax,
yes,
and if center says that no, I will impose the tax,
for major minerals.
but I'm giving you 1 minute.
For major minerals. Yes,
right.
yes.
But I'm giving you the entire, let us say entire.
Yes.
Does that satisfy what is given to the state under list 2?
Lordship may not just take giving.
Despite the impose.
Yes. Lordship may not just take giving. Entire assessment is by the state. Collection is by the state, special courts are set up by the states, All the parliament is doing is, don't go haywire in your levy. Suppose they leave it to the state government. Then any state government can levy any tax. So what I'm submitting is, the very fact that the entire money goes to the state itself shows that the state is not denuded of their taxing rights, taxing money. All happens, the ceiling limit is imposed. Like in sales tax, once you're a declared goods, you can't put more than 5%. Sorry.
56 interstate trade is only
Exactly.
by the central government.
Pardon me?
It's only by the parliament.
Yes.
And
Again, what happens is,
The power under Article 286
yes,
with regard to
interstate sales.
only the parliament.
Only when parliament can levy.
Only the machinery is by the state.
Yes, why I gave the analogy.
From the power to impose a tax.
No, why I gave the analogy is, after 6 years of independence, the state's absolute power became subject to limitations. Now, limitations can be in any way parliament wants. In sales tax, what did they did? They said not more than 5%, only single point levy. For minerals, they said, major minerals you can tax in the second schedule at these rates. So now suppose it is 8% ad valorem, it's an all India tax. Whether you find the coal in Bihar or you find the coal in Karnataka, it's an 8% tax.
So feeling the heat from behind.
Very much, Manoj. Well, unfortunately, I can't be pushed in front.
Thank you, Mr. Datar. Now, Mr. Datar, you have to tell us who is following now next.
Mr. Ghosh is following. I mean, he wants to take 1 minute to.
Just a minute, I'll take. I'm going next subject to what?
No, no.
90110.
No, at the detagging, I'll give the note tomorrow in my matter.
90110. I have only 3 points to make and I will not take more than 10 minutes. 3 issues have been troubling this honorable court. First, is there a possibility of a sovereign right of taxation to be ever denuded? That's the first thing. Whether the sovereign right of tax of a state can ever be denuded. That's the first question that has been troubling my lords. The second, has such a denudation ever happened under the current context? And third, whether the parliament can arrogate that right of taxation under 1897. These are the 3 very particular things, my lord. Insofar as the first issue is concerned, my lord, I'd like to place a judgment of the US Supreme Court, where the issue was of mineral right taxation exercised by the tribes, the Apache tribes. The Apache tribes under their formulation Lord, this judgment I had given it to the court master. This submission, this particular point is not there, this judgment, because I also fine-tuned my judgment based on the 455 US 130. 455 US 130 Marion. The opinion of the court was rendered by.
Compilation.
It's not there, but it has been given to the court master.
Marion, yes, we got it.
Yes, my lord. This was the case where, and I'll just briefly explain what had happened. The tribes, the Apache tribes were sovereign.
Yes.
They had the power to legislate and also impose tax. On minerals, they imposed a tax called severance tax. On non-tribe, non-Indians, so to say, and non-Indians challenged it. Issue that came before the US Supreme Court and the opinion of the court was by Justice Thurgood Marshall was sovereign's right of taxation cannot be denuded. However, the very wordings of the constitution of the tribes said, and I'll read that particular thing, my lord, text internal page 134. At the bottom, I'll just read the charter. Yes, please, yes. The bottom paragraph. This was the charter of the constitution. Inherent powers of the so-and-so tribe, including those conferred under section 16 of the Act of June, as amended, shall vest with the tribal council and shall be exercised thereby, subject only to limitations imposed by the Constitution of the US, applicable federal statutes, and regulation of the Department of Interior and restrictions are established by this revised constitution. Very similar in construct, that your power of taxation can be limited by the US Constitution or the federal government. In this case, the same thing is happening as well. In that context, my lord, three things the majority opinion said. This power can be used to restrain the tribes, and I'll take my lord where it is, to abridge that right, and also to take away their right. All the things are possible. I'll take my lord, kindly have page 141, internal page 141. Of course, second paragraph. Of course, the tribe's authority to tax non-members is subject to constraints not imposed on other government entities. The federal government can take away this power, and the tribe must obtain the approval of the secretary before any tax on non-members can take effect. These additional constraints minimize potential concerns that Indian tribes will exercise the power to tax in an unfair or unprincipled manner, and to ensure that any exercise of tribal power of tax will be inconsistent.
What is the next point?
Yes, Lord, that is one. So therefore, that is possible. Now, the second point is, if it is possible, then has it happened? Because the words used in entry 50 is that any limitation, and my lords have read the word any in the bearer bonds, in the electoral bonds case to means some, one, or all limitations. And therefore, it could go to anything, and reasonable restriction also has been meant to be complete prohibition. It is our submission, my lord, that section 9 of the MMRD and the architecture of MMRD has actually imposed an entire restriction on the taxing power of the state qua mineral rights. We apply the aspect theory. There is one aspect that has been written there, which is the taxes on mineral rights. There could be other aspects, we don't know. Subject to the states having that power on that aspect, state can levy tax. But the aspect of tax on mineral rights has been taken over by the parliament by virtue of section 9, because section 9 has all the ingredients of a levy, of a valid levy as per Gangasaran and Govindsaran. The taxable person is there, mineral right holder. Taxable event is there, the conferment of the right and extraction of the mineral. The measure and value of taxes, the rate of tax is there in as much as there is a rate, specific rate that is provided. So section 9 is the only sphere qua mineral rights, because there is nothing left there thereafter. Maybe there is other aspect of mineral rights that may be there, but that the state will have to find power, unlike the parliament, which has a residual power. And the third is whether the parliament can arrogate itself the power to taxation. Well, the submission is as follows. We apply the principle as applicable in doctrine of eclipse. My lord knows, if a pre-constitutional law was ultra vires the fundamental right, it is not dead and gone. It is in a moribund state, which means it is inoperative. Applying the same principle, as soon as the parliament exercises the power under entry 50, that whole taxing power is in a moribund state. It is inoperative. The purpose of 248 is to deal with such subjects and such enumerations which is active.
Can become inoperative.
Because conferment of power means that you must use that power. If you cannot use the power, it is in a moribund state. It has to that extent become dormant and ineffective. Therefore, that cannot be there.
Thank you, Mr. Ghosh. Thank you.
Obliged.
Now, who's next?
Yes, my lord, as per Ghosh.
Anything over and above what has been argued?
Yes, we have
We'll note your appearance.
sequence. By consensus, sir. So,
Sorry?
as per sequence. Lord, as per sequence, I am supposed to do. Lord, I am. Let's see. You can. I'm sorry. Mr. Datar is
Not like your SLP day, Monday, Fridays.
I'm so sorry, Lord.
Get T20, yes.
I'm so sorry, Lord. As per sequence, I was supposed to come, Lord. I am
Kumar.
As per sequence. I'm so sorry, Lord. This has happened at my turn. Lord, I am only answering few questions which have been raised, and as per my submission, Lord, few new answers can be given to that, Lord. One question which has been repeatedly asked by particularly by Justice Nagaratna and Justice Roy, Lord, that to what extent Parliament has taken over, Lord. And to that, Lord, Mr. Salve has referred that trilogy, and my submission is the consistency in all constitution benches except Kesoram is that total inundation in respect of both regulation as well as
inundation, total denudation.
Denudation, extraction, all denudation also a word has been used in Sandur, Lord. Denudation and Sandur and Bharat ko king coal has gone. Bharat denudation.
Right.
Sorry. Sorry. Bharat Coking Coal and Sandur has gone to the extent of saying that even executive power
All right.
under
I think
Article 1.
Let's
Lord,
start
then
the other
there's
side at
one more
3:30.
Lord.
Give 1 hour.
Lord, when
We've already exceeded
Mr. SG was citing that
Thank
form,
you.
Lord,
We'll-
my Lord was looking
Thank
for
you.
substantive
Thank you,
limitation.
Mr. Kumar.
My Lord,
Just tell us
rule-
who are the others who, please give us your appearances.
Lord, 227, 3, my Lord, there is substantive
Yes,
limitation.
yes, Mr. Dwivedi, please start.
9.7. In sequence myself.
Yes, Mr. Vasudev.
Sir. New point. New point.
Yes.
New point, sir.
9.7. 1 lakh.
New point
तो
statement.
सुन तो लीजिए।
Lordship, here I raise the point only fifth and
आपने
substance.
पहले
New point.
सुन तो लो जरा।
In sequence, sir, I was.
आपके पहले सुन तो लो। इतनी भी तो क्या जल्दी है? आधा घंटा है हम लोगों को। आपके पहले सीनियर काउंसिल है, तो 2 मिनट दे दीजिए।
That's it.
Just want to point out one fact. I beg to appeal Civil Appeal 945A of 2013. But we learn every day. Sir.
Yes, Mr. Vasudev.
I appear for the NTPC. They have given us submissions which are on record for supporting what everybody else says. I just wanted to point out a notification of the 1st of August 2077, issued under 2007, issued by the Government of India, which deals with the question of royalty and the calculation. And in para 4, it says, for states other than West Bengal, levy cess or other taxes specified to coal-bearing lands, the royalty allowed shall be adjusted for the local cesses, because we have a situation where the local cess comes in. So you have a question of a royalty. Now, if the local cess is to be there, then in keeping with the constitutional scheme of having a standard tax or a standard royalty all over the country, the local cess should be included.
Thank you, we got the point. Yes, Ms. Bhati. Thank you.
Just one more second, minute. In that context, I must say that in our cases, we are operating in Madhya Pradesh amongst other states as the NTPC, acting in the national interest. We are now being levied with a cess, which is very high, making it difficult to balance the finances with regard to the other states. So my respectful submission is this notification, cess should be a part of royalty, not excluding them. Of course, we will argue this before the other benches when it comes up, but this is a submission to your lordship.
To appear for 2 of the coal companies, my lords, my written submissions are already on record. The only additional point that I've made, my lords, which some of the seniors have touched upon, is the Coal Mining Area Acquisition and Development Act, my lords, which is the regime under which we operate. And there, my lords, the levy is by way of an amendment. The Act is of 1957. The amendment comes in 1971, by virtue of which we are paying something akin to royalty on the same rates to the state governments. So, my lords, we have an alternate submission. But, my lords, I wanted to bring that because as nationalized coal companies, we are, my lords, paying that to the state governments under that regime. Just 2 lines, my lords, I want to add, my lords. Firstly, my lords, your lordships are looking at the interpretation of entry 50, which is a taxing right, taxing power, but it is not eclipsed by a taxing power. It is eclipsed by a regulatory power. So my lords will, my lords, consider that aspect. The second thing, my lords, taxing power is limited, but the limitation itself is of very wide amplitude, because the entry reads any limitation subject to it being for mineral development. So the entry is smaller, my lords, and the limitation is wider, is my respectful submission. And though the entry is tax, but your lordships will not find a limitation which is of tax, because the entry does not contemplate a limitation of tax alone. My lords, one more submission, just additional, my lords, it fell from your lordships during the hearings, my lords, with regard to intergenerational equity. I also wanted to place, my lords, the aspect of intergenerational equity in, my lords, harnessing and development of the minerals and their usage in national interest for national infrastructure is an equally important component of intergenerational equity, my lords, that this generation has to bear in mind. I'm very grateful.
Ms. Patil. Yes.
Lordship, can I?
She's right. Yes.
Volume 2, page number 64. Bharati's tax is nowhere defined in the Indian Constitution. There are 3 essentials of the
three essential features of the tax in India. First is it can be imposed by the public authority or the, you can say that is the government. Second, it is the compulsory contribution to the government. Pardon?
Who are you appearing for?
Appearing for the IA number 237364.
Who are you intervening for?
Private party.
Which private party?
Not getting, sir. In MADA versus SAIL. IA number 237364.
What does the private party have to do with this litigation?
Yes, sir. These minerals are for the ultimate use and the benefit of the.
Can't continue ad nauseum like this. All kinds of private parties can't come here. It's a dispute between the.
Sir, let me say I have the locus and I can say before you. These minerals are for the ultimate use for every citizen of the India. In watches, in medicines, in everything of daily life, we use these minerals. So when the tax rates or the disputes of the center or the state are deciding that issue, then if the cost is higher, then every citizen will be impacted by this, sir. It is directly connected to every citizen of India.
All right.
Sir.
We are discussing and dilating upon the interpretation of three entries, my lord. Entry 23, entry 50.
That we now heard that for the last 3 weeks. Point.
The point is that the expression common in all the entries is mineral development. My lord, the entry 50, as my learned friend has just said, that is controlled by a general provision. Entry 50 is controlled by a.
Then why are you repeating what Ms. Bhati said? She made a very valid point.
Yes.
Now don't dilute the point which Ms. Bhati made.
Entry 50, my lord. In Tolok,
Thank you. Yes.
In Tolok, your lordship has held that the entry 23 has been carved out in view of entry 54 of list 1. So therefore, the entirety of, as if it does not exist. That is why
it's not carved out. It is subject to.
It says subject to means that the area of entry 23 has been carved out from entry 54.
No. Please don't say that.
Therefore, my lord, there is no entry 23 existing. That is why the fees, whether it comes under entry 66, was denied. Second is, my lord, in the second point. My lord, I have given a submission, my lord, in which I have pointed out 10 flaws or errors which is committed in Keshwaram, my lord. That has to be seen, my lord. I have given my submission.
Thank you. Yes, sir. What do you have to say?
My lords, I have an intervention on behalf of ESL Steel for Vedanta Group, my lords. Lot of submissions have been made on nature of royalty, whether royalty is akin to tax or royalty is a tax. My submission is converse, my lords. I am saying that royalty may or may not be taxed, but it is definitely not a consideration. And the proposition of law that I'm advocating is that any amount that a state or an instrumentality of a state which collects in order to perform a sovereign function, a constitutional function, or a statutory function, my lords, cannot be towards a consideration because what the state is doing is not a service, my lords. The consideration presupposes, my lords, whether it is understood under the contract.
So therefore, are you postulating that Vedanta can excavate as many minerals as it wants, and you're not bound to pay anything?
My lords, what they're bound to pay may be in the nature of tax, but that's not consideration, my lords. So
you can excavate from the bowel of the earth without having to pay anybody. That's your submission.
Not, my lords, the nature of that particular payment may not be treated as consideration because
that means you don't pay any consideration at all. All right, thank you. Who else? Who else?
May I permit it also? Point 7. Lordship, here I am discussing about the pith and substance. Doctrine whether law is valid by examining its dominant chemical engineering versus 9.901.7. Only two things here. One thing is Lordship already pronouncement by the Apex Court.
So Data,
later on legislation.
I think we rushed you a bit. Mr. Rakesh Dwivedi can start in the morning tomorrow fresh. Is that okay? We have left for 20 minutes.
Yes, as a lordship.
I think that's better. Mr. Datar, we rushed you a little bit. We'll give you the last word. You can wrap it up for us. One second. Please now, let's not go from the sublime to the ridiculous now, please.
Wait, please, Lord.
Mr. Menon wanted to have 2 minutes.
Yes, certainly, Mr.
Lord, I had occasion to assist its Honorable Court in the larger bench in the Tresiyama Jacob, which everyone was referring to. That is, where in Kerala, the minerals are vested in the private persons. Now, in that one issue was left open was.
Mr. Menon, why don't you do this? Just close everything.
Yes.
And give us your core consciousness. Tell us what you would like us to.
My point was that.
Just leave aside everything and just tell us what you.
Yes. My point is that.
Conceptually in your mind.
Yes, royalty and tax are mutually exclusive. And the royalty is a proprietary right, whereas tax is a sovereign right, prerogative right.
Yes.
Now, when State West Mineral, as per the Water Principle has present, all these principles followed by the Honorable interrogation, etc., it can be possessed separately. Minerals can be possessed separately because it's a subsoil right. Now, when you vest the mineral in the government, then government becomes the proprietor. Now, when you are saying taxation, it's a prerogative right. Can the state impose tax when you yourself is the owner? Of course, for the time being, probably it appears, in fact, my duty to assist the Honorable Court. Now, when they are collecting royalty, they are the owners. How can they impose a tax?
Permitted by Constitution.
Now, so far as the taxing power is concerned, entry 49 and 50. Yes.
Make the conceptual difference that royalty is something which you charge in exercise of your proprietary right.
Absolutely.
Tax is something which you levy
Correct.
in pursuance of your sovereign power.
Correct.
When the same entity wields two hats, you are both the proprietor of the mineral and yet you are also a sovereign. So imposing both is not inconsistent because you are exercising your right as a proprietor in
Now,
one
in
instance,
fact-
as a sovereign in the other.
In fact, one position I agree with, entry 49 and 50. These are to be read together. The entire power is vested with the state. I have no quarrel on that. Because entry 50 is carved out. Otherwise, the entire taxation power is there in entry 49. This is carved out for a limited purpose of bringing in a limitation by the parliament, by the law being passed by the parliament. So that aspect problem, I don't think I have anything. But when you are the owner, for example, let us assume that not in the case of a land revenue, and you are making an assessment and you are selling your own property. No. You are the owner. At the same time, you are exercising a prerogative right. Both these things cannot go together. The moment you become the proprietor, then you are not a sovereign, and vice versa. When you become the proprietor, you cease to be the sovereign. So when you are imposing a tax on your own property.
No, but it's not really, because what the state is doing is this. A private party, the lease owner or the leaseholder, has been given the right to extract. That private party extracts the material and removes extracts the mineral and removes the mineral. For that person has to pay royalty to the state.
Activity is being charged.
Right. And therefore, when the state now imposes a tax, it's not imposing a tax on itself. It's imposing a tax on a private party on the royalty which is paid by him for the extraction or removal of the material, of the mineral.
Yes. I got what's flowing from your lordship. So that's why, let's just have a look at entry 49 and 50. I'm not going to read out or anything.
Entry 49, entry 45 and entry 50. Entry 45 is land revenue. Entry 49 is land and building, and land is a bundle of right as per Halsbury, followed in Karageshwar or DK Trivedi or whatever it is. Now, out of that, you are separating this, as I already pointed out. Now, for that purpose, the power is always there with them. But in this case, by this, because probably I'm arguing against this thing about this thing. I mean, a tax when it is being imposed, it is not, sorry, when the restrictions are being brought in to the MMDR Act, Section 9, what is being, more stress was given. According to me, it cannot be. Because Section 9 is only a regulation. And Section 9(3) read with Schedule 2. What they wanted to rely upon is it is rather a tax that's imposed falling under 366(28). It can never be. That's my argument.
Thank you. Thank
But
you.
I know, my lord. Yes,
Mr. Datta.
No,
we'll give
my
you-
only proposition was an honor. If they become the honor, and if you are, and what is mineral right? That is something embedded in the land. It is embedded in the land. You are imposing a tax on that, and only to that extent is governed by that particular limitation.
Thank you, Mr. Menon. Yes, Mr. Datta, we'll give you the last word. You can take us through to the end of the day today.
Later.
There are 2 points I wanted to highlight. One was where Mr. Kambata made a very important point, and because of time constraints, he could not do it. And it's the context of what my Lord Justice Roy asked the question, that in the Constituent Assembly debates, there was a move to shift it back to Parliament, and Dr. Ambedkar simply says, no, there is no logical reasoning. My Lord, one answer could be in the debates which came before the Joint Committee, and my Lord, my friend, House of Commons, yes, yes. Lordship will just see the debates, give the volume. 4M, M for mother, at 54, and Lordship will just come to 56. I'm going to deal with that, and also Lordship asked the question, this tax on minerals versus mineral rights, that also I'll clarify. Yes, Lordship. 4M, M for mother.
M.
Yes, where is that? Page 56 about the third, Mr. Spence, I think must be Sir Patrick Spence. And Lordship will just come to just above the first paragraph, last line. Page 56. Lordship will come 5-6 lines down that. It starts with the word the first.
What are we reading, Mr. Datta?
No, we are reading a question where the matter was concerned by the House of Commons and earlier by a joint committee, whether the state should get an unlimited power of taxation or not. That was a short part. And there's a discussion. The other discussion is who owns the mineral rights and so on. That's not the subject matter from this bench. But what the bench said, I'll just summarize because time is short. The initial proposal in the draft was entry 54 was like the same thing. In that, at that time included oil also, but it was like 54. And the tax on mineral rights was not subject to any limitation. It was like tax on land and buildings, simply tax on mineral rights, taxes on mineral rights. That's all. When the matter came for discussion, Sir Craddock and Lord Percy, they said that, please see page 60. That sentence is important.
Page 60.
Yes. Yes. Please come to page 56. Second, the penultimate paragraph.
I have on a former occasion.
I have on a, all your also got it, no? I have on a former occasion. My lords have got. I have on a former occasion referred to unfortunate results which have occurred in the United States and elsewhere, where a variety of states have been allowed to deal with proprietary rights and regulations affecting the minerals of their own district. The same thing will happen in India if you have 11 states making their own laws with regard to rights of owners of minerals, whether they are vested in the crown or in private persons. It is exactly the same thing with the important question of taxation of minerals, one state imposing high taxes on mineral rights and other state imposing a different scale of taxation. This only leads to confusion and to a very uneconomic and non-commercial development of the mineral resources of a country. Therefore, I urge that as far as possible, we should take this opportunity to bring about one code of laws relating to as many minerals as possible throughout India. Now, please come to the, directly on page 60.
59.
Yes.
59.
At page 59, and Lordship, this is made at 7:19 p.m. Lordship has got a Lord E. Percy. At page 59.
By written submission.
We are following.
This is, I have quoted.
We are following.
No, not
Page 59.
Not Percy.
I have quoted.
Yes, I noticed Lordship has got 7:19 p.m.
Yes.
Yes, my lords have got it 7:19 p.m. Yes, I noticed that the government are not proposing to remove taxation of mineral rights from the provincial list where it is now. How can the federal government have power to regulate the development of mines if an unlimited power to tax rights is still left in the provincial legislature? Then the Solicitor General answers, and kindly come to the second paragraph. I now come to the questions put by my honorable and learned friend, member for Ashford, Mr. Spence, and the subsequent speakers. My view certainly is that these words clearly cover the power of vesting minerals in the Crown. The words would clearly entitle the Federal Assembly to make provisions as to concessions, and the words of amendments are wide enough to empower the federal legislature to cover all matters in development of mines, coordination, and so forth. Now, my lord, please come to find page 62. 60, no, with the taxation.
Yeah, this is it.
Yes. Please come to page 60. And please come to page below the Solicitor General, below Mr. Molson. Lordship has got it. Yes. Please, Mr. Molson. I'll read Mr. Molson, my lord. The learned Solicitor General keeps on referring of leaving it to the provinces. The responsibility for developing oil and coal is at present with the Government of India. What is being done under this is to transfer the primary responsibility from the center to the province, and at the same time,
provided subsequently it may be retransferred from the province to the center. The Solicitor General, I was speaking of the bill as originally drafted and comparing it with the result which will flow from this amendment. In the original bill, mines and minerals were exclusively provincial. Many matters which are now central are being transferred to the provinces, but would be out of order to go into a larger issue raised by my learned friend, member of Hastings. Lord Percy raised an obviously important point into which we shall certainly look. I can quite imagine a form of taxation which would conflict with regulation and development. In that case, I think I am right in saying that under this scheme I have in mind at present, list 1 wins. If there is an overlapping between list 1 and list 2, list 1 wins. And this amendment was accepted. Yes. And we come to page 62. Page 61 is a speech by Sir Reginald Craddock. And just the last 2 portions. Page 62, my lord. Second paragraph. There is a further point. Lordship has got it. There is a further point. There is a further point that great discrimination might be caused by heavier taxation being imposed in one province than in another. If mines were being worked in one province, say by a European or a Parsi, and mines were being worked in another province by persons of some other race and status, it would be possible for a province to bring about discrimination. One province might put a heavy tax on a European mining concern, while other province might put a low tax on an Indian mining concern. There is a great necessity for maintaining control of central government over the rates of taxes and so forth, merely with a view to securing uniformity. The other royalties and income would go to the province, and the province would go in the ordinary way, as they are doing now, administering those matters which they administer at present under mining rules and royalty rules, etc. Yes. If they want to alter these rules, they would require the sanction of central government. It is that way that uniformity can best be secured, while allowing the provinces to have legitimate income from their mining concessions, and at the same time avoiding all risk of discrimination between concession holders of different races. Lordship can say now different states. I thought that these facts, derived from personal experience, might usually place before the committee in consideration for so. Really, wording is because of uniformity.
I learned solicitor says on page 37 to 50
of my more on this era.
Yes.
Yeah.
So this debate shows why tax of mineral rights was subject to a law made by Parliament to maintain uniformity, as I said, to impose financial guardrails, financial limitation. That was the proposal. But questions came from the bench.
This is the control. Yeah, my friend points out that this was the confusion which was sorted out eventually by the 1948 Act, saying that, look, there'll be a Mines and Mineral Act.
Yes, and perhaps that could be an answer why Dr. Ambedkar felt that, look, there is no need to interfere with what was the earlier position. So you have entry 54, entry 23 and 50. Now the last point Lordship asked on taxes on minerals and mineral rights. I just put forth what I think, Lord. In para 400 of Justice Sinha's dissent in Kesoram, his Lordship rightly points out
that mineral rights are embedded in the earth. Only when the minerals are won do they become minerals. Only after the mining is done, excavation is done, they become minerals. Now, on the taxing of minerals, I would just submit, Lord, because
entry 84 of list 1, I'm talking of the pre-GST era, refers to goods manufactured or produced in India. Entry 84. There are judgments which say that coal is produced. Nobody can say coal is manufactured because it is in the earth. It is one, and once it is one, coal becomes produced. Then it is beneficiation takes place, purification. So coal is produced. Coal is entry 2701 of the Central Excise Tariff.
Lignite is an entry. Coking coal is an entry. Petroleum is an entry. Crude oil. So maybe once the goods are produced, a taxable event is the production of the particular mineral that could be subject to Central Excise Duty. Suppose the mineral is sold. Sale of mineral will be subject to sales tax. So maybe in the context of minerals, at the mineral right stage, the taxation is on the activity of excavation, mining, whatever it is. Because once a mining lease is given, the definition of mining lease is the activity of trying to win the mine from the mine which you got a lease. So mining rights is 50. Once the coal is produced or minerals are produced, and if they are mentioned in the tariff, it will be entry 84, list 1. If the minerals are sold, it will be entry 54, list 2. This could be the architecture of the taxation powers, is my humble submission. And again, Parliament has been very careful. Under section 14 of the CST Act, coal, iron ore, many minerals are declared goods. So you can't tax more than 4%, just was 3%, it became 5%. And you can't tax at more than single point. So if it is taxed by coal, say Neyveli Lignite Corporation taxes at the point of pithead, subsequent dealers when they sell it can't be taxed again. So this is my submission on tax on minerals and mineral rights. That's my submission. And not the only issue of subsoil, etc. We leave it later because this is yes. Sorry.
Lordship, can I get 30 seconds, Your Lordship? I'm appearing for one of the interveners. Can I just get 1 minute, Your Lordship? That's all I'm praying for.
Who is the intervener you are appearing for?
Your Lordship, it is IA number 55372. It's one Ganpati E Udyog, and there are other 800 petitioners for which separate SLPs have been filed. We have provided the list as well. Your Lordship, this is concerning the GST.
Said which corporate group have you been sponsored by?
No, we are not concerned. No, because Lordship reads the biography of Rufus Isaacs, Lord Reading. So he used to be in court till 5 and then go to the House of Commons, which would be KC MP in those days. And then the Parliament would go on in the evening. So after court house, Parliament would start and go late into the afternoon.
And in the anteroom of the Parliament, they used to serve.
Yes, so if it would not have been there, Winston Churchill would definitely have introduced.
Mr. Dwivedi, so we'll start tomorrow morning.
No, really,
I need one
we are
party to circulate.
extremely grateful to your Lordship for the
on
hearing.
Ganga development and its effect on taxation. One page.